Hi, welcome to Trials and Errors. I'm Mirriam. Today we're going to talk about Kyle Rittenhouse. He's the 17-year-old from suburban Chicago who one night decided to go to Kenosha, Wisconsin, where there were protests that turned violent in the evenings to protect the community. Kyle bought a gun. He bought an AR-15, but he didn't buy it directly because he wasn't allowed to. He had a friend of his who was, I think, 19, purchase the gun for him, and then he was going to transfer it to Kyle when Kyle was of age. Last summer, we know there were Black Lives Matter protests. Jacob Blake was shot 7 times in the back in Kenosha. And of course, people were very, very upset. Kyle decided to take it upon himself to protect one business in particular with a friend of his. It's the same friend that bought him this gun. He had purchased a sling, like a military grade sling, to put his gun onto so he could get it really easy if he needed to. And he went out into the night, met up with some other people who also claimed to be protecting the community, protecting local businesses. And at some point he comes across a gentleman who had apparently just been released from a psychiatric facility that day, and he killed him. Needless to say, shooting an unarmed man, it attracted some attention in the neighborhood, which was already, it was beyond a boiling point at this point. It was already on fire. And we can talk about the difference between peaceful protests and riots, but I don't really want to, because I want to talk about the law of self-defense as it relates to this particular incident. The entire issue with respect to protests and riots is a much deeper, much more philosophical conversation that I think is better suited for another time, when we're not busy talking about people who show up with AR-15s at night during protests and riots looking for trouble. Kyle was, there was a kind of a mob that surrounded him at that point, and he may very well have felt threatened. He was down on the ground, and there's a video of all of this. Of course, these days everybody just pulls out their phone and watches it all take place and then uploads it onto the internet. And Kyle says he felt threatened. One of the people had a gun, and so of course he did the only reasonable thing, which is shoot 2 more people. One of those people ended up dead. The other one was seriously injured. It turns out that nobody actually had a gun. One of the young men had a skateboard. It's true that, these people were not happy with Kyle Rittenhouse. They were really displeased that he had shot and killed someone just a few moments before. Leads me to wonder, is it self-defense? I think if you review the video, when you see him shoot these 2 people when he's on the ground, you could believe that. You could believe, yes, this is a legitimate self-defense claim. And let's talk a little bit about what self-defense is. Self-defense in most states is an affirmative defense. And what that means is that the state puts on its case and it says this particular thing was a murder. It lays out the elements of murder during the course of the trial. It will introduce witnesses potentially who say, they saw you do it, you admitted to doing it, there may be physical evidence, DNA, fingerprints, videotapes, what have you. Once they've presented their case, it's up to the accused to prove self-defense. If you say it's self-defense, you have the burden of proving it. Otherwise, generally in a trial, an accused, a defendant, has no burden of proof whatsoever. They can sit there silently the entire time, and the prosecution has to bring all of the evidence, and that evidence has to meet the threshold of beyond a reasonable doubt. So what do you have to prove if you're someone who pleads self-defense? This was a self-defense case. Well, you have to show that you were not the initial aggressor, meaning you didn't do an act that then caused the other person to basically have to defend themselves, or, was it a fair fight? Were you both involved in this in the same time? Then you have to show, if you weren't the initial aggressor, your fear was reasonable. Were you legitimately afraid, or reasonably afraid rather, that you would be seriously injured, you would face serious bodily injury or death? Now, the whole reasonable person standard is really interesting, considering I believe that the reasonable person was always meant to be a white man in society. So white men had a reasonable belief to be afraid when they were amongst a group of black men, for example, or in a predominantly minority neighborhood. So those were things that somebody could look at and say, well, it would be reasonable to be afraid if you were this kind of person in that kind of place. And I'm not sure if Wisconsin has a stand your ground law. In many states, you do have a duty to retreat if you can safely, unless you're in your home, in which case you have something that's called the castle doctrine, because you know, your home is your castle. So Kyle Rittenhouse's case brings up a couple of interesting points. The first is, if you shoot someone, but it's not the person that then comes and attacks you, are you the initial aggressor? I say yes, because you should not be able to, I don't know, walk into a Target, shoot a person, have a bunch of people come at you to either prevent you from shooting it or, I don't know, just being really angry that you just shot a person and killed him in cold blood, and then have you continue to shoot them saying that, you know, it was self-defense. I don't really know all of the facts of this case, and I don't practice in Wisconsin, so I can't say what would happen in Wisconsin in particular, but from what we know so far of this case, young Mr. Rittenhouse was in the wrong from start to finish. When he was asked by the Washington Post, he actually gave them an interview, and they asked him, why did you bring this gun? He said, well, I brought it because I thought I would be killed. But we know that that's absolutely not true. He brought the gun because he could. That's really it. There was no other reason for him to go, and not only that, but he was not legally allowed as a 17-year-old to carry that gun. So self-defense is always tough. In the best of circumstances, it's hard. I don't know how hard it will be for Mr. Rittenhouse and his defense counsel to prove self-defense in this case. I think, however, he may not be convicted. Now, Kyle Rittenhouse's case took place late last year. I think it was August of 2020. So why are we still talking about it today? Well, we know that he had a $2 million bail set, and we know that the judge probably set that $2 million bail thinking that Kyle would never be able to make it. I don't think the judge thought that a group of right-wing gun aficionados, anti-Black Lives Matter people would raise the necessary money for him. So Kyle was released. And at some point, the prosecutors got mail that was supposed to be delivered to him, and it was returned to them, that he no longer lived at that address. And when they went out to that address, he wasn't there. I mean, he was just gone. And just so you know, when you're out on bail or out on bond, you're not allowed to just move without telling people. Your every move is regulated, it's watched, it's supervised. The prosecutor asked the court to issue a new arrest warrant for Mr. Rittenhouse. And the reason why Kyle had moved was because he had gotten death threats, and so he was afraid for his life. Police told him to just move and not tell the court or the prosecutor where he was moving to, because Kyle didn't want his whereabouts known, and the prosecution objected to that. They didn't want his address to be under seal, because when you go to court, your address is on the record. They ask you what your address is, and you have to tell them. Kyle listened to the cops. You know, the cops just said, just move, and don't tell anybody where you're going. So he did. The judge in this case refused to issue a new arrest warrant, and the prosecutor asked for an additional $200,000 bail, and the judge refused to increase his bail, which I find to be a particularly interesting thing, because I know that if I had a client that wasn't white and had moved without telling the court, they would not be sitting at home free. When we talk about Kyle Rittenhouse, we talk a lot about white supremacy. And I have to be honest, I haven't read a lot about his history, what he was about, what he was into. He was a 17-year-old kid. But what we do know is that white supremacists came to his rescue, and he is their poster child. Whether or not he accepts that is a different story, and how that's going to play out at trial, we'll just have to wait and see. If you like this video, and I don't mean you like it because you like the contents of it, because it's kind of harsh, right? But if you like the contents and you feel like you learned something, give it a thumbs up. Hit the notification bell so you'll know next time I give you some awesome information. And also, subscribe. It's free and it helps us. Until next time, bye.